Okay, members of the jury, you have been handed the closing jury instructions. There's one more document you'll get before the parties argue, but we're gonna give that to you right after the break. I'm going to read through these, and then we'll take a short break. So these are jury instructions 18 and 22 through 42. If you turn to page 2, and you can make notes on these if you'd like. So page 2 is jury instruction number 18, which has already been read to you, most of it, as modified, because I did modify it during the trial, and I read it to you during the trial as it stated right here. So now you've got the complete 18, the modified 18. Turning then to jury instruction 22, which was also read to you during the trial on limited purpose evidence. Turning then to 23, a closing roadmap. Members of the jury, you have now received all of the evidence. 3 things remain to be done. First, I will give you additional instructions that you will follow in deciding this case. Second, the lawyers will give their closing arguments. The plaintiff will go first, then the defendant, then the plaintiff may give a rebuttal. Finally, you will go to the jury room to decide the case. In the jury room, you will have 2 main duties as jurors. First, you will decide from the evidence what the facts are. You may draw all reasonable inferences from that evidence. Second, you will take the law I give you in the instructions, apply it to the facts, and reach a verdict. Instruction 24, closing arguments. When the lawyers give their closing arguments, keep in mind that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. Counsel, could you remove that easel? It's kind of blocking my view of the jury. Number 25. You can just shove it over next to the screen. Legal rulings. During the trial, I have made certain rulings. I made those rulings based on the law and not because I favor one side or the other. However, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. 26, fault defined. Your goal as jurors is to decide whether Terry Sanderson was harmed, and if so, whether anyone is at fault for that harm. You must also decide whether Gwyneth Paltrow was harmed, and if so, whether anyone is at fault for that harm. If you decide that more than one person is at fault, you must then allocate fault among them. Fault means any wrongful act or failure to act. The wrongful act or failure to act alleged in this case is negligence. Your answers to the questions on the verdict form will determine whether anyone is at fault. We will review the verdict form in a few minutes after your break. Instruction 27, negligence defined. You must decide whether Gwyneth Paltrow or Terry Sanderson was negligent, or whether they were both negligent. Negligence means that a person did not use reasonable care. We all have a duty to use reasonable care to avoid injuring others. Reasonable care is simply what a reasonably careful person would do in a similar situation. A person may be negligent in acting or in failing to act. The amount of care that is reasonable depends on the situation. Ordinary circumstances do not require extraordinary caution. But some situations require more care because a reasonably careful person would understand that more danger is involved. To establish negligence, Terry Sanderson has the burden of proving that 1, Gwyneth Paltrow was negligent, and 2, this negligence was a cause of Terry Sanders' harm. If you find that Gwyneth Paltrow was negligent, then you must determine whether that negligence was a cause of Terry Sanderson's harm and whether Terry Sanderson sustained damages. Gwyneth Paltrow claims that Terry Sanderson was negligent in causing his own harm, and that should read, and in causing her harm. To establish Terry Sanderson's negligence, Gwyneth Paltrow has the burden of proving Gwyneth Paltrow has the burden of proving that 1, Terry Sanderson was negligent, and 2, that this negligence was a cause of Terry Sanders' harm and her own harm. I'll send in a corrected instruction 27. If you find that Terry Sanderson was negligent, then you must determine whether his negligence was a cause of his own harm and her own and Ms. Paltrow's harm, and whether Paltrow sustained damages. Instruction 28, allocation of fault. If you decide that more than one person is at fault, you must decide each person's percentage of fault that caused the harm you determine was suffered in this case. This allocation must total 100%. Mr. Sanderson's total recovery will be reduced by the percentage of fault that you attribute to him. If you decide that this percentage is 50% or greater, he will recover nothing. The same is true of Ms. Paltrow's recovery. When you answer the question on damages, do not reduce the award by Mr. Sanderson's or Ms. Paltrow's percentages. I will calculate that later. Instruction 29, violation of a safety law. Violation of a safety law is evidence of negligence. Terry Sanderson claims that Gwyneth Paltrow violated Parts A and B of the following safety law, and Gwyneth Paltrow claims that Terry Sanderson violated Part A of the following safety law. This is Summit County Ordinance, Section 523, reckless skiing. A, reckless skiing prohibited. No person shall ski in a reckless or negligent manner so as to endanger the life, limb, or property of any person. B, skier's duty to injured party in the event of collision. Any skier involved in a collision resulting in injury to any person shall immediately stop at the scene of such collision and render to such person injured in such collision reasonable assistance, including the caring or the making of arrangements for the caring of such person by a physician, surgeon, or hospital for medical or surgical treatment, if it is apparent that such treatment is necessary, or if such caring is requested by the injured party. If you decide that Mr. Sanderson and or Ms. Paltrow violated the safety law, you may consider the violation as evidence of negligence. If you decide that Mr. Sanderson and or Ms. Paltrow did not violate the safety law, you must disregard the safety law, and decide whether they acted with reasonable care under the circumstances. Jury Instruction 30, I've already determined that Gwyneth Paltrow did not leave the scene of the accident without giving her contact information. Jury Instruction 31, spoliation. Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed. Sanderson asserts that the GoPro video of the ski collision never existed. If you find that 1, a GoPro video of the collision likely existed, and 2, that any such GoPro video was in the possession or control of Sanderson, and 3, that the plaintiff intentionally or negligently disposed of or lost the GoPro video of the collision, or otherwise failed to offer a reasonable excuse for failing to preserve the GoPro video of the collision before a defendant had an opportunity to review and evaluate it. Then you may, but are not required to, conclude that the evidence would have been unfavorable to Sanderson. Instruction 32, Introduction to Tort Damages, Economic and Non-Economic Damages introduced. I will now instruct you about damages. My instructions are given as a guide for calculating what damages should be if you find that either Terry Sanderson or Gwyneth Paltrow is entitled to them. However, if you decide no one is entitled to recover damages, then you must disregard these instructions. If you decide that Ms. Paltrow's fault caused Mr. Sanderson's harm, you must decide how much money will fairly and compensate him for that harm. If you decide that Mr. Sanderson's fault caused Ms. Paltrow's harm, then you may award Ms. Paltrow $1, which is the maximum amount she seeks. There are two kinds of damages, economic and non-economic. I will explain the difference between them. 33, proof of damages. To be entitled to damages, a party must prove 2 points. First, that damages occurred. There must be a reasonable probability, not just speculation, that a party suffered damages from the other party's fault. Second, the amount of damages. The level of evidence required to prove the amount of damages is not as high as what is required to prove the occurrence of damages. There must still be evidence, not just speculation, that gives a reasonable estimate of the amount of damages, but the law does not require a mathematical certainty. In other words, if a party has proved that they have been damaged, and they have established a reasonable estimate of those damages, the other party may not escape liability because of some uncertainty in the amount of damages. 34, economic damages defined. Economic damages are the amount of money that will fairly and adequately compensate a party for measurable losses of money or property caused by another party's fault. Mr. Sanderson is not claiming any economic damages. Therefore, you should not award Mr. Sanderson any economic damages. Ms. Paltrow is seeking $1 in economic damages. 35, non-economic damages defined. Mr. Sanderson is seeking non-economic damages. Non-economic damages are the amount of money that will fairly and adequately compensate Mr. Sanderson for losses other than economic losses. Non-economic damages are not capable of being exactly measured, and there is no fixed rule, standard, or formula for them. Non-economic damage may still be awarded even though they may be difficult to compute. It is your duty to make this determination with calm and reasonable judgment. The law does not require the testimony of any witness to establish the amount of non-economic damages. In awarding non-economic damages, among the things that you may consider are 1, the nature and extent of injuries, 2, the pain and suffering, both mental and physical, 3, the extent to which Mr. Sanderson has been prevented from pursuing his ordinary affairs, 4, the degree and character of any disfigurement, 5, the extent to which Mr. Sanderson has been limited in the enjoyment of life, and 6, whether the consequences of these injuries are likely to continue and for how long. While you may not award damages based on speculation, the law requires only that the evidence provide a reasonable basis for assessing the damages, but does not require a mathematical certainty. I will now instruct you on particular items of economic and non-economic damages presented in this case. Instruction 36, pre-existing conditions. Terry Sanderson is alleged to have had physical, emotional, or mental conditions before the time of the ski collision. He is not entitled to recover damages for those conditions. However, he is entitled to recover damages for any aggravation of the conditions caused by Gwyneth Paltrow's fault, even if those conditions made him more vulnerable to physical or emotional harm than the average person. This is true even if another person may not have suffered any harm from the event at all. Gwyneth Paltrow has the burden to prove what portion of the alleged harm is the result of pre-existing conditions. If you are unable to make such an apportionment, then you must conclude that all damages, if any, you find were suffered by Mr. Sanderson were caused by Ms. Paltrow. 37, mitigation of damages. Each party had a duty to exercise reasonable diligence and ordinary care to minimize the damages caused by the other's fault. Any damages award should not include those that could have been avoided by taking reasonable steps. Terry Sanderson has the burden to prove that Gwyneth Paltrow could have minimized her damages but failed to do so. Gwyneth Paltrow has the burden to prove that Terry Sanderson could have minimized his damages but failed to do so. If a party made reasonable efforts to minimize damages, then your award to that party should include the amounts that he or she reasonably incurred to minimize them.
Your Honor, my memory is that jury instruction 38 was stricken by both parties yesterday.
Okay.
Is that your memory?
It wasn't.
It was not.
It was not stricken.
I apologize. Please proceed.
Okay. 38, collateral source payments. You shall award damages in an amount that fully compensates Terry Sanderson. Do not speculate on or consider any other possible sources of benefit Terry Sanderson may have received. After you have received your verdict, I will make whatever adjustments may be appropriate. 39, four-person selection and duties and jury deliberations. Among the first things you should do when you go to the jury room to deliberate is to appoint someone to serve as the jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all members of the jury get the chance to speak. The foreperson's opinions should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict form on behalf of the entire jury. In the jury room, discuss the evidence and speak your minds with each other. Open discussion should help you reach an agreement on a verdict. Listen carefully and respectfully to each other's views and keep an open mind about what others have to say. I recommend that you not commit yourself to a particular verdict before discussing all the evidence. Try to reach an agreement, but only if you can do so honestly and in good conscience. If there is a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own. In reaching your verdict, you may not use methods of chance, such as drawing straws or flipping a coin. The verdict must reflect your individual, careful, and conscientious judgment. Instruction 40, do not resort to chance. When you deliberate, do not flip a coin, draw straws, choose opinions at random, or use other methods of chance. Instead, you must weigh the evidence carefully and come to a decision that is supported by the evidence. If you decide that a party is entitled to recover damages, you must then agree upon the amount of money to award that party. Each of you should state your own independent judgment on what the amount should be. You must thoughtfully consider the amount suggested, evaluate them according to these instructions and the evidence, and reach an agreement on the amount. You must not agree in advance to average the estimates. Instruction 41, agreement on special verdict. After the break, I'm going to give you a form called the special verdict that contains several questions and instructions. You must answer the questions based on the instructions and the evidence that you have seen and heard during this trial. Because this is not a criminal case, your verdict does not have to be unanimous. At least 6 jurors must agree on the answer to each question, but they do not have to be the same 6 jurors on each question. As soon as 6 or more of you agree on the answer to all of the required questions, the foreperson should sign and date the verdict form and tell the bailiff that you have finished. The bailiff will escort you back to this courtroom. You should bring the completed special verdict form with you. And then jury instruction 42 I'll read to you at the end of the trial. So that completes these instructions. I wonder if you could write your names on the top of that, because as you noticed, I did make some changes to a few of the instructions as we went along, and I'll have the bailiff insert the new and take out the old, if you could do that, the new instructions, before they're given back to you. Yes?
Are names and numbers or just names?
Pardon me?
Names and numbers or just names?
On the verdict form, the foreperson will write their number and their name when they sign it. And there's only be one signature on it, which would be the foreperson. And when I select the 2 jurors that will unfortunately have to leave us before deliberations, I'll just tell you your juror number. I won't say your name, and I'll give you further instructions about those 2 individuals. So I'll do that in a few minutes after all the arguments are completed. So at this time we'll take a recess, and thank you.